Good morning, everybody. We Untitled report for Institute of Intellectual Property and Competition. And today we will discuss a topic concerned to contract law, making a contract. Making a contract. If you would like to follow the previous lesson, you can follow an overview of contract law on the YouTube channel. At this lesson, the student will understand the offer and acceptance, understand the basic rule governing contract, and recognize when contract is voidable. So about legal document, you can follow the Constitution, Vietnam, Civil Code 2005, and then 2015, and some decision and guidance of government. And here the case. First of all, you need to distinguish the difference between the civil law system and the common law system. Whether the contract under the common law system will be governed by case law, the president, and the judge can interpretation the decision according to the circumstances. Whether the civil law will be really well to codify court and some regulation, we have the mandatory effect. So very different. Just pay attention. Offer. Concluding a contract is when the party express their will to each other, jointly establish contract through consultation, exchange, negotiation with each other, according to principle and procedure, freely, prescribed by law in order to establish, replace, change, or terminate the civil rights and obligation. So when we conclude a contract, it's very important that we base on very general principle of the civil law system. Second, we need to have an offer and we need to have an acceptance. The proposal, Article 386 state, offer to enter into a contract means a clear expression by the offerer of his intention to enter into a contract and to be bound by such offer, made to another specific party or to the public. Example, the gas agent ABC sent an advertisement to family XYZ with the content, if you buy gas from our agent from July 1st, 2016 to July 30, 2016, you will receive a 20% discount and receive promotional gift worth value price for $100,000. If you have a question, any question, please call us as that numbers. So just spend a few minutes to think about, is it a contract issue? And please explain. So I'm sure that you will have an answer. Please comment below your answer. When you're making a proposal, an offer to enter into a contract has specific time for reply and offer enter into contract with a third person during the time limit for reply by the offeree. If the offerer failed to enter into a contract with the offeree and offeree suffer damage, the offerer must compensate the offeree for such damage. Example, on November 2020, you can read the case. The client, after that, they change his decision by taking another taxi. So this can meet the John violate the offer into the contract. So I'm sure that you have an answer. So third one, about information in entering into a contract. Article 387. Each party must notify the other party of any piece of information affecting the acceptance of offer to enter the contract by the latter party. When you conclude a contract, information very important. So maybe some information is very valuable. In this age, the information technology, you can see that information at value 1,000 times. So by that way, a party receive any secret information from the other party during the process of entering into a contract. It must protect the information and may not use it for its own purposes or other illegal purpose. All right. So that's a right to access to information of the party. Cannot hide information. And also the civil law regulates some time limit where an offerer has specified such time limit and when an offerer had not specified the time limit, the offerer to into the contract is effective and from the time the offeree received the offer. The following case shall be deemed to be receipt of an offer into the contract. First case, the offer is delivered to the place of residence of. If the offeree is a natural person, or the offer is delivered to the head office, if the offeree is a judicial person. And then the offerer is placed into the official information system of offeree, and when offeree know about the offer to enter into a contract by way of other means. Modification and withdrawal. An offerer may modify and withdraw an offer. If the offeree receives notice of modification or withdrawal of the offer prior to or at the time as receipt of the offer. And also the law regulates the offerer clearly specify the circumstances in which the offer could be modified or withdrawn, and such circumstances have in fact arisen. Terminate. An offer to enter into the civil contract shall be terminated in the following cases. First, the offeree reply that offer is accepted. Second, the offeree reply that the offer is not accepted. Third, the time limit for acceptance has expired. Fourth, when notice of modification or withdrawal of the offeree becoming effective. Fifth, when notice of rescission of the offer become effective. And lastly, as agreed by the offerer and offeree within the time limit within which the offer to enter the contract remains effective. That is the case. So we can see an example. Max sent Lily a letter, invited her to purchase 10 boxes of each class cosmetics, 10 million. Lily agreed to buy after learning the price, but requested that Max give her a 10% discount on the shipment worth. Max answered that he was willing to share, but only at 5% discount. Lily agreed to buy, but continued to pay the price at above shipment of $8 million in a letter to Max. When Max did not respond, Lily wrote another letter. This time agreed to purchase the aforementioned shipment from Max at 5% discount. So, has Max and Lily deal been final yet? So, you can find your own answer according to the theory we have learned. Second, we talk about acceptance. When an offeree replies to the acceptance of the entire content of offer, we have an acceptance. So in some cases, silence is not considered as acceptance of the agreement. And civil law also have some time limit for the acceptance. We have very about the limitation. The Article 395, some limitation 396, and then we have some example. So please do the example. The first question is, has the contract between Max and Lily been concluded yet? The second, if B write letter agree to buy the above shipment from Max for $8 million, and Max reply yet, but then Max die. Will Lily receive the good and pay at a reduced price? And why? So please have answer. Also, we have some general transaction condition. If the offeree accepts to enter into the contract, it is considered to accept this term, and some validity of the general trading condition has been made public to the party established transaction. And lastly, the general transaction condition must ensure equality. If the general transaction condition have provision to exempt the party offer the condition, increasing liability and eliminate the legitimate interest of the other party, the provisions shall apply. Places. The contract also applies some condition of places. The place where contract is entered into shall be as agreed by the party. If there is no agreement, such place shall be at the residence of the individual or the head office of the legal entity having made the offer to enter into the contract. Terms. A contract is entered into at the time when offeror received the reply accepting to enter into contract. And so we have some definition of Article 400. Effectiveness at Article 401. So if you want to see more information about a contract, please contact us at a YouTube channel, and then we will happy to explain for you more about a matter every weekend, Sunday, 10 a.m. in the morning. Thank you very much for your listening, and if you have any information, just send to us. Redaction report from Institute of Intellectual Property and Competition. Thank you. See you again.